Senator Blumenthal.
Thanks, Mr. Chairman. Thank you, Judge, for your patience and your perseverance. I want to begin just by thanking you also for an extraordinary moment in our history. I think we all, as Americans, feel excitement and pride in really making history here. And the old saying, a picture's worth 1,000 words, as I look at your parents and your husband and your daughters, what I see is America and the best of America. So I think we should all feel that excitement and pride in this moment and the extraordinary journey that has brought you here. You will make the court look more like America, but also think more like America in the obstacles and challenges that you've overcome to be here. We don't know all of them, but you will provide a very important perspective, indeed a unique perspective that the court needs more than ever at this moment in its history. There are a lot of people who are book smart. There are not as many people who are person smart, and you are both. That kind of emotional intelligence is what our courts need, not just our Supreme Court. So I want to really begin by asking you, as a role model for others, to talk a little bit to the young women and girls of America, particularly Black young women and girls, about those challenges and obstacles that you've had to overcome to be here and what's helped you do it.
Thank you, Senator. I am humbled and honored to have the opportunity to serve in this capacity and to be the first and only Black woman to serve on the United States Supreme Court. I stand on the shoulders of generations past who never had anything close to this opportunity, who were the first and the only in a lot of different fields. My parents, as I said, were the first in their families to have the chance to go to college. I've been the first and the only in certain aspects of my life. So I would say that I agree with you that this is a moment that all Americans should be proud.
Now, you've never been a prosecutor. A lot of us on this panel have been prosecutors. I was the U.S. attorney, the chief federal prosecutor in Connecticut for 4.5 years, and then I was attorney general of my state for 20 years. But I would say one of the most meaningful cases in my career was as a defense counsel. I was asked by the NAACP Legal Defense Fund to represent a Black man on death row in your home state of Florida. He had been convicted of murder and rape, had been on death row for a number of years. And I took the case because I was asked to do it, and eventually, somewhat to my surprise, found, in fact, he had never done the crime of which he had been convicted. And eventually, we won his freedom because the prosecutor in the case concealed evidence, which was a violation of his constitutional rights. And he was a free man as a result. Your husband, as a surgeon, saves lives. Lawyers don't do it often. But I know from personal experience the importance of having a good representative, an advocate, a counsel, because in that case, he had been denied it when he originally went to trial. And only after years in both state and federal courts was the truth vindicated. So I want you to talk a little bit about why it is important for defendants to be represented by zealous, really aggressive and energetic advocates who tell the truth to the court, put on the evidence, and present the best possible case for a defendant accused of a crime.
Thank you, Senator. The idea is one that is rooted in our Constitution. The framers were concerned about government overreach in a lot of different areas. The provisions of our Constitution are protecting individual liberty from government overreach. This is why we have provisions about limited government, and there are many provisions in the Constitution that are limiting government action when it comes to the deprivation of liberty, because the framers understood how important liberty is to our society. And so there's the Fourth Amendment, there's the Fifth Amendment, there's the Sixth Amendment, there's the Eighth Amendment. These provisions are crucial, and it is zealous defense counsel that ensures that the government is protecting these rights, that ensures that these rights are protected and that people are getting due process in the criminal justice system. And that's to all of our benefit. That helps everyone in America when we ensure that liberty cannot be denied without due process. It's defense counsel, as I said, who are making arguments, and they're not condoning the criminal behavior. They're making arguments on behalf of clients in defense of the Constitution and these constitutional values. And as a judge, I now see how important it is for me to be able to make my decisions after hearing from both sides. That's crucial. We have an adversarial system, which means that judges are presented with arguments from both the prosecution and the defense. And only when I'm able to hear from both sides can I make a just, fair determination. And fairness is the hallmark of our constitutional scheme, and it's what makes us the best criminal justice system in the world.
And it's not only the reality of fairness, but also the perception of fairness, the public's understanding of how courts work, that is essential to the credibility that courts have, correct?
That is correct.
And so I feel very strongly, I know that a number of us on the committee agree, that more transparency, more visibility is important for the public to understand what goes on in the courtroom. I know you feel transparency is a good thing. You've been asked about cameras in the courtroom. I'm a supporter of Senator Grassley's Sunshine in the Courtroom Act, as well as Senator Durbin's Cameras in the Courtroom Act. I am hopeful that the court, the United States Supreme Court, actually will back these proposals because their support would be very important. Tell me how you feel about the basic principle of transparency and more visibility.
Well, Senator, one of the reasons, as I said, that I write such long opinions is because I want everybody to know exactly the arguments I've considered, the facts that I've reviewed, and in pretty fine detail, the course of my reasoning. And I've done this in 570 opinions. I think it's important for public confidence, as you say, for people who are bound by the law and who are affected by the courts to know what the court's views are. With respect to the issue of cameras in the courtroom, I understand that that is something that is proceeding through Congress, and if I was confirmed, I would look forward to talking with my colleagues to understand the positions that people have regarding that issue.
I appreciate that response. One of the other areas that I think is important to transparency and to public trust and confidence in the court is visibility as to its own decisions, which I think is directly contradicted by the shadow docket. You've been asked about it before, but I just want folks to understand that some of the most important decisions of the Supreme Court have been decided, or at least issues resolved, without oral argument, without briefs, without any public explanation. A controversial travel ban has gone into effect. The first federal execution in 17 years was permitted. Statewide COVID restrictions were enabled. The collection of data in the 2020 United States Census and enforcement of voting restrictions in the 2020 presidential elections, as well as decisions relating to immigration and blocking the Biden administration from enforcing a federal moratorium on evictions imposed because of the COVID-19 epidemic. Americans have a right to an open, full, fair proceeding with a record of the court's reasons for making decisions. So I hope that you will urge your colleagues, when you talk to them about cameras in the courtroom, also to do less on the shadow docket. And I hope that perhaps, if they don't, Congress will take some action. I finally want to ask, so far as this issue of transparency is concerned, about codes of ethics. You have followed a code of ethics as a district court judge and court of appeals judge, correct?
I have.
Does that code of ethics apply to the United States Supreme Court?
My understanding is that it does not.
Correct. And my hope is that you will perhaps urge your colleagues as well to support a code of ethics. They haven't done so as yet, but I think we have an obligation in the Congress to set forth a code of ethics, and I hope they'll support it. Senator Durbin and others of us have supported that kind of measure as well. And I would just ask you whether you'll raise it with your colleagues if you're confirmed.
Senator, certainly if Congress is taking anything up that requires our review, I would absolutely consider it, and even if not, I would consider it.
Thank you.
Talking to them about it.
Thank you. You know, the reason I raise these points is that I respect the United States Supreme Court. I've argued 4 cases before it. I was a law clerk to Justice Blackmun, who, by the way, was from Minnesota, Mr. Chairman. In fact, he was known as one of the Minnesota Twins when he was appointed, because he was thought to be exactly like then Chief Justice Warren Burger, who also was from Minnesota, in his very, very conservative views. And as it happened, Justice Blackmun became one of the most progressive members of the court over the years that he served. He had a capacity for growth and for learning and listening, which I believe you have, and I think it is one of the most important characteristics of anybody who serves on the court. But I do think the court's crisis of legitimacy is the result of divisions within the court, the polarization and politicization that has drawn lines, the process that has happened in recent years in confirmation proceedings. And so I really think that consensus building bridges with your colleagues, will be immensely important. I think that's one of the reasons that the president chose you, having talked to him about it, that you have that kind of persuasive and forceful intellect, but also the personal charm and warmth and depth that will enable you to do it. Maybe you can tell this committee about how you worked on the Sentencing Commission, for example, or in your previous experiences on that kind of consensus building.
Thank you, Senator. Consensus building was one of the things that Justice Breyer was particularly good at in terms of his personality. In the time that I clerked for him, I witnessed the way in which he continually reaches out to colleagues, continually seeks common ground. And it's something that I would hope to be able to emulate if I were to be confirmed. When I worked on the Sentencing Commission, the commission is a 7-member body working on sentencing policy, which is at times a pretty contentious effort because we're talking about criminal justice. As commissioners, we are working on policy issues related to appropriate sentencings, and by statute, the commission is a bipartisan group. And during my 4 years as a commissioner, I was able to work well with other members of the commission to find common ground, to work on issues, to come together. And the vast majority, I heard a statistic that something like 95 or 97% of the votes that the commission took were unanimous. And that happened because of a lot of effort and an intention on the parties, on the part of all involved, to see if we could work together. And that would be the kind of thing that that I would hope to do if I was confirmed to the Supreme Court.
You've mentioned in your previous testimony the challenges of applying the law to evolving and new technology. Obviously, the internet raises exactly those questions. Congress passed the Electronic Communications Privacy Act in 1986, when the internet was barely recognizable. It was nascent, just starting. And now, our nation faces a mental health crisis. It is partly aggravated by the pandemic, the isolation and anxiety that's resulted from it, but also by the internet and by the tech platforms that drive toxic content at children as a result of these black box algorithms that nobody really understands. Literally, no one understands because the tech platforms want to keep them secret. And we are trying to upgrade the law and update it to give parents tools to have greater visibility as to what their children are doing, and to give parents and children tools to protect them against some of the bullying and eating disorder content and even suicidal and substance abuse stuff that they are driven to see. And Senator Blackburn and I have introduced a bipartisan measure, the Kids Online Safety Act, that will provide a more modern solution to a modern problem, to update the law to account for the role of social media in our ongoing and aggravating mental health crisis in this country. Do you agree that it helps the Supreme Court and judges in general to do their job when Congress updates our statutes to account for technological change?
Thank you, Senator. The role of the court is to interpret statutes when there are disputes related to the statutes, and in circumstances in which statutes have not been updated, I don't think it's surprising to note that there are disputes about the meaning of the statute, about how it applies. And so to the extent that Congress undertakes to make amendments and make the changes, I think it helps courts. Maybe there'll be fewer disputes or easier disputes to resolve.
Easier disputes to resolve in the sense that, and I've seen it happen, a judge will say, I don't know what Congress meant to do in this kind of situation because this law was written at a time when none of this stuff now existed. I'm sure you face that situation. I think it's true of social media and the dangers to children as a result of the toxic content that they often find and often seemingly are addicted to use again and again and again because it's part of the business model of those social media and big tech platforms.
Yes, I have faced this situation. One of my cases, the Alliance of Artists and Recording Companies versus General Motors, is a case that I ended up writing a couple of opinions about, and involved a statute of Congress related to digital recording audio devices and whether or not royalties were required for the purchase of those kinds of devices. And it was enacted at a time in which recording technology was at a different stage than it is now. And disputes arose that came before me regarding whether or not to apply the royalty requirement in that statute to modern recording devices, and in particular, the recording devices that are now in automobiles. When you take your CD and you put it in your own car and record onto the hard drive of your car, is that the same thing as putting your CD in one of those machines that records from CD to CD, and you give the second recording to all of your friends? That was what the statute was originally meant to cover, and the question was whether recording to your own car's hard drive counted. And it was a very interesting interpretive exercise, but again, it was the kind of thing in which I was focused on trying to ascertain what, based on the text of the statute and the definitions in the statute, what Congress intended this statute to cover.
And cars, other devices, appliances at home, collect huge amounts of data, don't they? And as consumers, we feel we own that data. It's ours. But it can be bought and sold, exchanged, and mined in a way that right now consumers have no consent over. And it enhances the dominance of just a few of those tech companies, just a few of the corporations. Corporate power is emboldened and enabled in many respects by the amount of data they collect. It's also enabled by forced arbitration. We've had a reference to it already today with respect to complaints about sexual harassment, which fortunately we have addressed. I've been proud to work on the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which President Biden signed after we passed it just a few weeks ago. I've heard harrowing stories from survivors of sexual assault and victims of workplace harassment who were silenced and denied justice by forced arbitration. But forced arbitration applies as well to everybody who has a cell phone. You have a forced arbitration agreement. Many workers have forced arbitration agreements. Nursing homes have forced arbitration agreements. The point is that you have dedicated your life to access to the courts, the right of a trial, the right to a jury, the right to a judge. None of it is possible where there is a forced arbitration agreement. That's why I've worked on a measure called the FAIR Act that would make any forced pre-dispute arbitration agreement invalid and unenforceable if both sides want arbitration, that's fine, but access to the courts should be available to everyone. I know that you're limited as to what you can say about measures that are before us and policy issues, but I hope that you will consider the trend that the court has adopted in support of forced arbitration and denial of rights like class action, and review whether they are appropriate. Let me just finish with a couple of quick points. First of all, on the Harvard Law School, Harvard Law Review article on registration of sex offenders, convicted sex offenders. I must say, I read this article several times. In my view, it is analysis, not advocacy. Would you agree?
Absolutely, Senator. As a law school student, I was trying to do what law school students do, which is analyze a new set of legal provisions. These laws were new, and I was trying to assess what criteria courts could use to look at them. I was not making an argument about them at all.
Exactly. And by the way, one of those statutes was in Connecticut. It was challenged on constitutional grounds, double jeopardy. It went to the United States Supreme Court. I defended it there. It was upheld 9-0. I don't know whether your article was cited, but I would put this law review article very much in the category of analysis, the distinction between prevention and punishment. I would call it protection, not punishment or prevention. That's the argument that I made to the Supreme Court. I ask that this article be put in the record, Mr. Chairman.
Without objection.
By the way, it took me 2 or 3 times to get through it, so no disrespect to you or the Harvard Law Review. The issue of child pornography, you mentioned, I think, that in your decisions on these sentencing cases involving child sexual abuse material, which, by the way, I agree is absolutely horrific, abhorrent. It's the reason that Senator Graham and I have actually sponsored a measure called the Earn It Act that addresses it. But you said that you imposed a sentence that matched the recommendation by either the prosecution or the probation office in most of the cases where you did that sentencing. Is that right? Do I have that in mind?
Yes, Senators. In looking back at the records concerning my cases, it looks as though I had 14 cases that involved either child pornography, interstate travel to meet up with a child for sex, the sex crimes related to children. And in 10 of those 14 cases, I imposed a sentence that was consistent with or greater than what either the government or the prosecution requested.
The probation office.
Excuse me, sorry, the government or the probation office.
And let me just ask you, the probation office is an independent arm of the court that investigates the defendant, looks at the crime, the defendant's background, his family situation, all of the relevant factors involved in sentencing, including the sentencing guidelines, and then independently and impartially makes a recommendation, presumably to serve the interests of justice in that particular case based on the individual facts there. Is that roughly a correct description?
That is correct, Senator. The probation office works within the court system. They are independent of the parties, and they investigate and make recommendations in cases concerning what the probation office thinks is an appropriate sentence.
Thank you. Let me just finish by saying much of America is watching these proceedings on a split screen. On one hand, they are literally seeing the death and destruction in Ukraine, Russia's brutal, barbaric assault on individual rights, basic freedoms that we often take for granted here. And we are exercising those rights right here. You are a teaching lesson. This proceeding is a teaching lesson about the importance of democracy. The people of Ukraine are fighting for it. They are dying in their neighborhoods and streets and their homes. They are huddled in basements. Their men and women are resisting valiantly and bravely against a huge military force that Russia has unleashed and a reign of terror from the skies simply because they believe in the ideals of freedom and law that we are seeking to preserve here. And so on this side of that split screen, I think it's important that we do our best to honor the norms and the rules that you've sought to uphold throughout your life. And I'm proud and excited to be here with you and your family as we go through this process. And I look forward, as I hope many of us do, to a bipartisan majority in support of your candidacy. Thank you. Thanks, Mr. Chairman.
Thank you.
Thank you, Senator Blumenthal. I'd like to bring everyone up to date. We have several considerations. The remaining senators for questions, the endurance of our witness, Judge Jackson, votes on the floor, request for compassionate release by a number of people in the audience. Here is where we stand. We're going to have Senator Hawley, followed by Senator Hirono. Then we're going to take a 20-minute break because that's when we think there'll be some votes on the floor. We can take care of those and get back in 20 minutes. Then we will return from